Hello, this is Will Fontenot with Fontenot Spivak in Bountiful and Woods Cross, Utah. And today we're going to talk about what are valid expenses for alimony purposes in light of the standard of living, and when a court can either strike or adjust those claimed expenses to go into the financial declaration. When you're involved in a divorce case where there's an alimony claim, you're going to be given the opportunity to fill out a financial declaration and claim certain expenses. The court then will be able to scrutinize those expenses, and the other side, of course, can argue that those expenses were not really valid because they weren't a part of the marital standard of living, and then the court will have to make the determination about whether that's true or not, whether those claims for expenses are valid or whether they are invalid. And this case is going to help us understand what the court can do and what the court cannot do when it is evaluating a party's claimed expenses for alimony. Okay, this is Knight v. Knight, 2023 Utah App 86, Utah Court of Appeals case. You can actually Google this and read it for yourself if you just put that information in there. This was Judge Faust. There's a lot of appellate decisions out there involving Judge Faust from the 3rd District Court. And then let's go skip down. This case did involve other issues. In fact, one of the issues involved a trust that was awarded solely to the husband here, but we're not going to talk about that. For this video, we're just going to talk about the alimony analysis. All right. So as I talked about before, the real issue in this case was the fact that the judge either eliminated some of the wife's claims for expenses or the court reduced it, and then Rebecca appealed some of those decisions. The first was the health insurance amount. Rebecca asserts that the district court abused its discretion in reducing her claimed expenses for health insurance. She made a claim for $757 per month. She testified that this was a quote, "I sought out. It does not have any deductible. Historically, our deductible was put on an HSA card that was covered by the Knight Group." I think that the Knight Group was just Jared's parents, I think, that were covering the deductible. So you can understand here, they had a deductible policy during the marriage, but Rebecca was claiming $757 per month in the insurance premium for a no deductible plan. The court reduced Rebecca's health insurance expenses to $411 per month, the number Jared gave as the historical amount the parties paid for health care services. Rebecca took issue with this. She appealed, and she did not prevail on this because the truth is that deductible payment that the Knight Group was paying for the couple was considered a gift, and past gifts are not to be considered in the alimony calculus. Accordingly, the court did not abuse its discretion when it determined that Rebecca did not provide qualifying evidence of her future health insurance expenses because she submitted only a quote for a plan without a deductible. The parties both testified that they had a deductible during the marriage, and Rebecca is not entitled to a health insurance plan better than the one the parties had during the marriage. So a party is always entitled to an equal amount for whatever the category is, but you can't have better than or more expensive than what the parties had during the marriage. So she prevailed on that. The next issue that Rebecca had here was the personal grooming, because the court reduced her claim from $949 to $500 per month. And the main reasons why the court decided to reject that claim or reduce that claim was because Jared didn't have a claim for personal grooming, and then also because the court just thought in its own judgment that $949 was too much and it should be reduced to $500 per month, believing that $500 per month was more reasonable. And both of those reasonings for why it would reduce it down, both of those were rejected by the Court of Appeals here. The court also stated that Jared did not ask for any personal grooming as a part of his expenses relating to the marital standard of living, and he was not getting the $500 that Rebecca was being awarded. The court had a big problem. The Court of Appeals had a big problem with the fact that the court kept relying on what Jared had claimed and then adjusting Rebecca's claims based on what Jared had claimed, the Court of Appeals said, no, you can't do that. You can't just strike one party's claimed expenses because the other party doesn't submit anything for that expense. The court would have acted within its discretion if it had found that Rebecca's evidence unreliable or had determined that Rebecca's claimed expenses were unreasonable in light of the couple's marital standard of living. That would have been fine, but that's not what the court did. The court's inquiry should have been rooted in Rebecca and Jared's marital standard of living as indicated by their historical spending. The court didn't do that either. The court didn't really say, well, yeah, that's what they spent. They spent $949 a month on Rebecca's haircuts, nails. I think she even claimed that, body waxing and that. Look, no matter how silly it is, silly an expense is for your common household or even to the judge, if the parties spent it, then it's going to be allowed as a claim for alimony purposes. The court can't just use its own judgment about what's reasonable and unreasonable. The court has to really rely on what the parties did. We have explained that alimony is not limited to providing for only basic needs, but should be fashioned in consideration of the recipient spouse's station in life in light of the party's customary or proper status or circumstances. Throughout the marriage, one spouse may spend more, even significantly more than the other on personal grooming, entertainment, travel, or any number of other expense categories. A partner may embrace the age-old adage's modernized mantra of happy spouse, happy house, may derive independent pleasure from a spouse's purchases, or may observe a spouse's spending habits, whether for monthly follicle treatment support treatments or jazz tickets only one spouse actually uses through gritted teeth. But for the sake of calculating alimony, we assume that the parties agreed on their household expenditures such that whatever was historically spent by the parties during the marriage constitutes the couple's marital standard of living. Okay, so you have to understand that if you're in a marriage that you're really not that happy about, and especially in a marriage where one of the spouses is spending a lot more than the other, and you have a real problem with the amount of spending that's happening, you better either get that spending under control or divorce that person as soon as you possibly can. Because the longer you allow that person to spend on, excessively or spend it on things that you don't agree with, it's going to be considered part of the marital standard of living, whether you agree with it or not, or whether it's reasonable or not. And the court isn't going to care that you brought it up with your spouse and said, hey, we need to stop, spending so much on this. If it happened, the court is going to assume that you agreed to it. So you either need to get that under control, or you need to just start the divorce process and start divorcing that person now, because the longer you allow it to occur and just let it slide, the greater your alimony is going to be. And it's going to be based on these things that you really didn't like that your spouse was spending money on. All right, let's talk about savings. Rebecca asserts that the court wrongfully entirely rejected her expense for a savings plan of $2,500 per month. Here, what the problem with the trial court's decision was that the trial court really rejected the savings plan claim because it just didn't appear that they were doing that every single month. And the Court of Appeals said, no, it doesn't need to be all that regular for this to be a validly claimed expense. The critical question is whether funds for post-divorce savings, investment, and retirement accounts are necessary, because contributing to such accounts was standard practice during the marriage and helped to form the couple's marital standard of living. So if your income is coming in and you're spending it, obviously those expenditures are going to be part of the marital standard of living, but apparently also your savings are going to be considered part of the marital standard of living. So if you have a practice of saving a certain amount of money during the marriage, then that's going to be allowed to be an expense that's claimed by the spouses at the time of divorce. So just understand that if you decide to save, then that saving can also, come back to bite you as well if it's part of the standard of living. All right. So there, the Court of Appeals remanded this because the court's focus strictly on monthly saving habits is myopic and at odds with precedent. And the case was remanded to the court to determine whether the facts as found meet the criteria for a savings-based alimony award. All right, retirement. Here, Rebecca made a claim for $500 per month that this was a necessary expense for retirement savings, but the evidence adduced at trial established that the parties never saved $500 a month for retirement. And so let's talk about the Court of Appeals here, what they found. And here again, the trial court improperly discussed the point that Jared did not ask for retirement as part of his expenses relating to the marital standard of living. That was the problem that the Court of Appeals had with the approach that the trial court took, that it really doesn't matter if the other spouse is claiming an expense or not. That just doesn't matter. But rather than relying on this point to deny Rebecca's claim for a retirement savings provision in the alimony award, the court stated that this point gave further credibility to the fact that the parties did not regularly save for retirement. More importantly, and unlike for the savings category, the court's conclusion that there was no standard practice of saving for the retirement flows from its findings on the irregularity of the parties saving for retirement while married. So I think the problem here is they only actually set aside money for retirement 3 out of the 27 years of marriage. That certainly is not regular enough. So the court was upheld here in deciding that there should be no money allowed for retirement savings because they just didn't do it very regularly at all during the marriage. All right. Rebecca also made a claim for additional capital investment funds of $7,279. Rebecca argues that this was an amount based on funds the parties historically had available from Jared's family wealth for discretionary investment. But as we discussed before, past gifts are excluded from the alimony calculus. The funds that were historically available for investment were gifts, and as such, they are not properly considered as a standard practice contributing to the marital standard of living. So claims for expenses that a spouse makes because they just believe that it's something they're going to need going forward, those claims are not supported. Those claims should be rejected because they're not a part of the historical practice of the parties. It wasn't a part of the marital standard of living, so it cannot be allowed on the financial declaration. So just keep that in mind. Of course, people want money for certain things after divorce, but they're only going to get those things if it was part of the standard of living during the marriage. So that's the case of Knight v. Knight. If you have an alimony issue or an issue involving expenses, give us a call, Fontenot Spivak, 801-312-9330, 801-312-9330. We're located in Bountiful, Utah, and we serve Salt Lake County, Davis County, and Weber County. Thanks.